Hello and welcome to the Frantic Rattlet webinar. This is a webinar series that we do monthly on a Tuesday every month and discuss a topic relevant to educators. This month we're focused on homeless students and the legal issues surrounding supports of homeless students and also the disputes that arise about whether a student is in fact homeless. Today, I will be speaking, Jennifer Smith. You have my contact information there, and I'm joined today with Amy Dickerson, another one of my partners here at Frantic Rattlet. To get started, we would like to share a video to set the stage on this issue.
My name is Grace Wright.
And my name is Malik Ali Kashan.
We're homeless.
Where am I gonna stay for the night? Like, what am I gonna eat? Like, so much stress.
And kind of hard moving around.
Life is hard, really.
We're living with someone else because my mom got evicted from where we lived at. And the lady, she was nice enough to let us come into her home and stay with her till my mom found a new apartment.
Me and my mother had a little miscommunication, and one word led to another. I don't want to get too deep into it because I still love my mother, but it just wasn't right at the moment, so she just kicked me out.
I didn't think we were going to make it through. I thought I was going to have to drop out. I wasn't going to be able to go to college.
Probably would have dropped out if it wasn't for the transportation and the housing.
When I was at school, I knew that I would have food, I would have like shelter, a place like to be under.
I know I can live better than this if I just stay focused and just pave my way forward.
We're not helpless. It's just when we get the resources we need, we can make it work.
It's important to just stay focused on what really matters.
My long-term goal as of now is to go to college, get my degree in education, and then pass the LSAT, go to Harvard, and become a lawyer.
I think my first step is, I'm sure all colleges got mechanical engineering. My first thought is about, oh, let me meet the coach, let me see what the basketball program is about, what they gonna do for me to help me so I can get to that next level.
With that, specific to here in Illinois, the recent numbers that came out from ISB showed an increase in the identification of homeless students. It's not known whether that is due to better, basically, child find and districts doing a better job of identifying and properly labeling students as homeless, or if that is a genuine increase in the students experiencing homelessness. But regardless, it is a significant issue that's borne out in the numbers reported by ISB. Today we're going to first go over the basics, the legal basics as far as the laws that apply, what rights and responsibilities are, the dispute process. Again, there are situations where schools become aware that perhaps a student is not homeless, who's seeking the benefits of primarily registering in a district perhaps where they do not reside. And then our tips and reminders as far as best practices and takeaways from today. Throughout, I encourage, please, if you have questions, use the webinar feature. We're happy to try to get to any questions that we possibly can throughout the 30 minutes. So with that, I'll turn it over to Amy.
Thanks, Jennifer. So as hopefully most of all of you know who are with us today and listening in your respective schools, the districts do have an affirmative responsibility to identify all homeless students. And in most instances, families will not say that they are homeless. And so staff should be trained to identify common signs of homelessness, particularly at the time of enrollment and registration. So a student is considered homeless if they are sharing the housing of other persons due to loss of housing, economic hardship, or a similar reason, if they are living in motels, hotels, trailer parks, or camping grounds due to a lack of alternative adequate accommodations, if they're living in an emergency or transitional shelter, abandoned in hospitals, living in a public or private place not designed for or ordinarily used as a regular sleeping accommodation for human beings, if they're living in a car, park, public space, abandoned building, substandard housing, bus or train station, or similar setting, or if they otherwise lack a fixed, regular, adequate abode. So at the time of enrollment and registration especially, staff should pay attention to any indication that a student may be in one of these living situations. For example, if often school districts will use the particular enrollment papers to have students complete that are termed special residency forms when students and families are sharing the housing of other persons. Staff should be particularly mindful that any families that are sharing the housing of others, they should be particularly mindful of what those particular reasons are as to why they're sharing the housing of others and why they're living with families, to rule out any indications of homelessness. So again, those who are sharing the housing of other persons due to a loss of housing, economic hardship, or similar reason would be considered homeless. So things to watch out for is if the reasons why a family says that they are living with another family is due to being evicted or having an inability to pay their rent, mortgage, or other bills at their prior home, or due to some sort of loss of housing, those are all indications that that family may be homeless. Likewise, I've seen more questions recently regarding families that may be living in motels or hotels. So again, keep in mind that any family who's living in a motel or hotel due to a lack of alternative adequate accommodations would also be considered homeless. So if students or parents come in and expressly indicate that they are homeless, or expressly indicate that they are living in any one of these living situations or lack a fixed, regular, adequate abode, or provide facts or information that should put the district on reasonable notice that the student may be homeless, the student must be immediately enrolled. Even if there are questions that the district still has about their living situation, they must be immediately enrolled and referred to the homeless liaison. Parents should still complete all required forms, but enrollment shouldn't be delayed based on the fact that those forms have not yet been completed.
And so, Amy, when you say staff should be trained, this is really your frontline staff, those who interact with people when they're registering, depending on what the school's process is.
Absolutely. And the Department of Education actually expressly recommends that those particular staff who are in charge of enrolling and registering students be trained to identify homeless or possible homeless situations, and then particularly know when to refer those to the homeless liaison. So with that, when we're talking about homeless liaisons and the obligations for homeless liaisons under federal law does require that every school district have I'm just trying to make sure that our slides keep up with what I'm saying. There we go. So every school district has to have a staff member who's designated as a homeless liaison, and for districts to ensure that the school districts are meeting the particular obligations that school districts have under federal and state law to comply with ensuring that students who are homeless are immediately enrolled, are getting the access to the services that they need, and that the schools are meeting their obligations to carry those duties out. So there's a particular resource, especially for those of you who are newly designated homeless liaisons at your school districts. In addition to getting the resources that I know our ROEs provide to homeless liaisons, the Department of Education has also issued a number of technical assistance documents out of its National Center for Homeless Education. And there's a particular guidance document that's part of their best practices in homeless education brief series, specifically on what the requirements are of local homeless education liaisons. And that can be a helpful document to get an overview of what those requirements are. And those include having the obligation to ensure that the district is identifying homeless students, that the district's published a notice of the educational rights of students who are experiencing homelessness, and that that's disseminated in locations that are frequented by families and youth experiencing homelessness. The homeless liaison should be ensuring that any students who are enrolling newly enrolled at the school district, that the prior school that they attended is contacted for the record, that the students are referred for appropriate services such as health services, dental services, mental health, substance abuse, housing, and other appropriate services. And again, ensuring that school staff are receiving the appropriate professional development and support that we just recently talked about. And, you know, not only with regard to the those staff who are frontline and making sure that they're trained, but then also ensuring that, you know, one particular tip to keep in mind is that to the extent your homeless liaison is not the person at your school who's also tasked with residency and conducting residency investigations at your school districts, you want to take the step to make sure that you're having close coordination with the homeless liaison and the person at your school tasked with residency issues to ensure that there's close coordination and collaboration with those issues. So when a child does become homeless or when a child enrolls and is homeless, the parents of the homeless child have the option to enroll the child or continue the child in the student's school of origin or the school of their attendance area. So the school of origin is the school that the child last attended when permanently housed, or the school in which the child was last enrolled. So the parents have the right to enroll the child in the school of origin if they choose, or in the school where the student currently resides. One thing to note here is that it is the parents' right to choose which one of these schools they would like their child to attend. Federal law does give some opportunity for school districts to weigh in on this decision when they find that it might be in the best interest of the student to attend one school over another. But here in Illinois, the right does absolutely fall to the parent. And with that, I'll turn it over to Jennifer.
Great. So then the question is, so what assistance is available for homeless students? The first would be when you're looking at fee waivers, free lunch and breakfast programs, waiver of all mandatory school fees. In my experience, there's not a lot of dispute about that. That happens pretty automatically. The next that requires more investment of time and resources is the issue of transportation. First, transportation should be provided by the parents, or if they can. If they make there is a requirement that they make a good faith effort to transport the student. But if the student, you're thinking about a student that's often living outside of the district at this point and coming back to their school of origin, that's where the transportation gets more complicated. And the district where the student attends does have an obligation to provide that transportation. However, if the student is residing outside of the district, both the district where the student resides and the district where the student is going need to coordinate on a transportation plan. If they can't agree, they split the cost 50-50. So the default is each district bears half the cost of transportation. But that there can be some creativity. You know, if one district has a bus that could get the student basically to the boundary, and then the other school district has their bus pick the student up, there's maybe ways to be somewhat creative. Or if there's a public transit option that could be worked out and then funded. Where it gets more expensive is where taxi service is required and there's really no feasible public transportation option. That does get quite expensive, and again, in the absence of any other agreement, the districts would split that 50-50. In my experience, sometimes those discussions are complicated in that you're reaching out to another school district, how responsive that district is. You know, you get kind of muddled down in the logistics of this one, but it is an obligation clearly under the law to work this out.
Jennifer, on that note, I've got a question recently with regard to, you know, what if a school district feels that the transportation situation especially is no longer in the best interest of the student. In other words, that the student being transported and spending so much time in a taxi or other mode of transportation to be transported from where they're currently living to their school of origin is resulting in, such a negative, consequence to the student that the school, or that there's some concern that it's no longer in the best interest of the student. What are their options? And one of the things that the law does allow for, while it doesn't, still ultimately up to the parent as to decide what school that the student attends, the law does allow for a teacher, the school, or the parent to call a meeting whenever they feel that the transportation situation is such that it may not be in the best interest of the student anymore. And the law actually specifically requires that meeting be convened if travel time is longer than 1 hour each way. So if that is something that there's any issues with regard to concerns that might be a situation that's presenting itself in any schools, that is resource that one can use, perhaps with the assistance of the ROE.
Correct. Yeah, you can force the meeting and see how persuasive your educators can be in convincing the parent to go to have the student attend the district where they're residing, as opposed to the district of origin. With that, so this slide focuses on a 2017 law that passed that really provides some interesting opportunities for districts to be perhaps creative and flexible in how they address homelessness. So under this 2017 Act, districts can use transportation funds to provide homeless prevention assistance. So what that means is, let's say you're going to pay for a daily cab for a student that's going an hour. So those transportation costs are going to be pretty high, frankly. You can, but if, let's say, the family is a little bit behind in their rent, they live in your district, if they had some sort of rental assistance, they could stay in the district and not move to grandma's an hour away to double up. This law does provide districts the flexibility to use the transportation funds to help the family with rental assistance, which could be a practical way to avoid the transportation costs of an hour away. So it could actually be more cost effective and, better support the family, keep them housed within your district. It's an option. It's frankly not one that I've heard a lot of districts using, but perhaps because there haven't been dispute. I'm sure when you give this assistance, it's not likely to result in calls to your lawyer, because I'm sure people would be grateful for that. Speaking of calls with your lawyer, we'll next turn to the dispute resolution process. So there are certainly times when school districts uncover, hey, we have a student identified by the parent as homeless who we have reason to believe is not homeless and should not either be attending our district at all because they're not actually residents, and that's why that's probably the most common reason we see what are believed to be false homeless claims is a student that does not live in the boundaries the family wants them to attend, and so they claim homelessness as a way around the residency requirements. ISB does have a relatively new procedural guidance out as far as what the dispute resolution process is. That's very specific, and if you have one of these situations, I'd advise, we have the link there. It is worth the read because it gives a very practical step-by-step process. I would say I've gone through several of these hearings, and my takeaways are that regardless of what the law is, at the bottom line is that if a family does not have a legal right to stay where they're living, so if they're doubled up, let's say, and they're doubled up with grandma, and there's a lot of question about, well, really they just want to live with grandma, they're helping provide care to grandma, it's not because they're homeless. What the outcome of those dispute resolution process, in my opinion, is whether there's any kind of rental agreement or formal legal right for the parents to stay with grandma. I've had situations where a parent even acknowledged they were doubled up just to save money. They only wanted to buy a house with a yard. Well, we might not think of someone as homeless who is trying to save money to buy a house with a yard and have that be their threshold of housing. But where there's a doubled up situation, I've mostly seen the outcome favor the family unless there's some sort of rental agreement. That's not the letter of the law, but that's how I'm seeing it generally applied. So the dispute resolution process, you can get to the bottom of those issues, but it's not a full-blown federal trial. It's a rather informal process, and unless you have clear evidence that a student's not homeless, it may not be worth the resources. With that, I'll turn it back to Amy for some tips and reminders.
So we've got a few particular tips and reminders here, particular issues that we've seen arise, particularly this fall in terms of questions that we've received here in our offices. And so, with that, first is, and this is something that we've covered at the beginning here too, but it's worthwhile to repeat that, again, keep in mind that parents don't have to use the term homeless to be entitled to services and immediate enrollment in your school district. So to the extent that you find yourself or any other administrators who you're working with, saying, well, they haven't used the word homeless, they haven't said that yet, if you're otherwise seeing indications that the students may be homeless based on the information that they are communicating to you, it's important to work with your homeless liaison to make sure that you're addressing what the appropriate best steps are for that student. So again, the time to particularly do that and pay attention to that is at the time of enrollment, really paying attention to what the answers are that the family is giving as to why they are living in a particular situation. And if you don't have those answers, one of the things to consider is, to the extent you're not already doing it, is to use housing questionnaires as part of your typical enrollment forms. These are something that we offer in our residency toolkits for those of you that are listening that use those. And these can be quite helpful so that if a family does present at your school saying that they are living with another family who are residents in the school district, then you can provide them with, what's often referred to again as that special residency form. It will ask a number of questions about the circumstances that are surrounding that living situation that can really help you identify, not only are they appropriate residents from a residency standpoint, but those are also the times then to really pay attention to any indication that they might be homeless, even if they actually don't use those terms. So another thing that we want to keep in mind is to really communicate with the family and the Regional Office of Education prior to initiating the dispute resolution process. And some of this is for the reasons that Jennifer described in terms of really thinking about the resources that you're putting into that dispute resolution process, but also what we're really seeing in our experience in dispute resolution meetings with ombudspersons, as well as what we're seeing from ISB guidance that was recently issued around the process, is that there's really an expectation that school districts are trying to work out with the family ahead of time prior to getting to that dispute resolution meeting table, what the issue is. And so to the extent that there is a concern that a family is actually not homeless but is presenting and saying that they are homeless, and prior to initiating that dispute resolution process, once you've immediately enrolled the students, you may be gathering facts with regard to what that particular situation is for that family or what you believe it to be through either your questionnaires or through other investigative steps. It's really becoming a best practice now to, approach the family with that information and have a communication to assess what their response is, to see if that perhaps brings any further insight for you as to whether or not it makes sense to continue with the dispute resolution process or not. one of the things when you're at the table, the ombudsperson will ask is, have you engaged in a pre-dispute resolution meeting with the family? And, that routinely as often occurs with the ROE as well. So that's an additional step that you'll be expected to take. So another thing that we're seeing more districts do now is reaching out to the ROE prior to sending that dispute resolution letter and making sure that they are part of the process as well. And finally, one of the things to also keep in mind is that for those families who are sharing the housing of others due to economic hardship or lack of housing or other similar hardships, that Illinois law does expressly allow for school districts to conduct a review as to whether such hardship continues to exist after the passage of 18 months and then annually thereafter. So we've been getting this question recently as well as to, if a family has been living and doubled up with a family for, a year, 2 years now, at what point do they no longer become homeless? And while there is no particular time period where somebody may no longer be homeless under the law, the law does expressly allow for you to be able to conduct that review at 18 months to assess whether or not they actually still meet the definition of homeless.
Great, Amy, and we did get some questions. First, one question is, what about preschool students? First of all, they are covered by the law, so we are talking also about homeless preschool students should you have that type of program and they would qualify as you are the school of origin for that student. And then the question turns to, what about transporting either preschool students or perhaps special education students who you can't, there's concerns about just putting them in a cab and the supervision of them in transit. So this is the area where transportation does get very specific to the student, and we'd encourage one of those collaboration meetings between both districts that are involved and the parent. In general, one of the questions was, should the district then pay to transport the parent if there's concern about transporting the student alone? That would not be my first go-to in that situation. If a student requires an aid, adult assistance, in order to be transported, it would be a better practice to provide that in some way, whether it's a bus aid, whether it's an aid in the taxi cab, although you would want to closely coordinate. I wouldn't assume that every preschool student necessarily needs an aid to be transported. It really is case by case.
A couple other questions. So one is, well, what if the family's moving into the area? Are they required to attend a school where they live? So again, if a student is homeless, then the parent of that student does have the right to either have the student attend the school where they're living if they recently moved into, for example, share the housing with another family, or they have the right to attend their school of origin. So again, that falls on the parent's right as part of that choice of schools option under the law. Another question was whether we can elaborate on what constitutes that 18-month annual review process and what that should look like. So expressly under the law, state law says that the districts can, at that time of a review, request information from the parent or guardian that reasonably establishes that hardship still exists. So that could include affidavits, so sworn statements from the parents as to what's occurring, as well as other, specific answers to questions that you can inquire to them as to, how long have they, confirming how long they've been living at the home, what their particular economic situation is, if they are currently now supporting or providing support for the living situation in terms of helping to pay bills or rent or things of that nature. If you have our residency toolkit, one of the forms that we specifically provide as a sample form for school districts in there is a specific form to use when you might be conducting this 18-month review process, where you would be informing the parents that you are just reaching out to confirm their status and then engaging in a series of questions to perhaps try to elicit some of this information.
With that, I'll answer one quick last question. It is, do we have a right as a school district to verify a student's doubled up via a home visit? In the ISB guidance, it is clear that districts can do a home visit, but if the parent refuses to let you in the home, you can't use that as evidence either way. So you can show up. It's frankly probably the best evidence we get from school districts is either they use their own staff or they use a private investigator who observes the student. Let's say every day they're leaving from a home that's clearly theirs and out of the jurisdiction. They're not homeless. They're routinely staying there, and it's a home that's habitable, let's say. So you've observed that. You've seen their toothbrushes. That usually is very good evidence in these hearings. So home visits are a good tool and allowed. But again, if they say no at the door, that's as far as you can go. So with that, we want to put out a save the date for our next webinar, October 23rd. This one is somewhat exciting. I'll have Amy describe. We have some leaked Title IX regulations. So
for those of you paying attention to the news and social media lately, there's been a lot of buzz with regard to the anticipated proposed regulations that the Department of Education is expected to be issuing with regard to Title IX, and specifically regarding schools' response to sexual harassment. So at our next month's webinar on October 23rd, we'll be discussing the current status of Title IX in light of these expected proposed regulations. And we'll make time to discuss what school administrators need to know to comply with Title IX as it currently stands under the law, and what's expected to change under the proposed regulations. So we hope you will join us then.
thank you.